Welcome back to Autism Live, and we're so excited that we're welcoming Bonnie Yates to the show again. She's a regular here. We absolutely adore her. She's a special education attorney extraordinaire, and she's an amazing woman, artist, and a fabulous mother, and so we're thrilled that she's here with us. And Bonnie comes... What's that?
Don't get me in trouble.
And Bonnie is, she comes to us from the law offices of Hirji and Chow, which we also love in Culver City. Bonnie, tell us a little bit about Hirji and Chow and your disclaimer, please.
Okay. Hirji and Chow is a 6-attorney law firm in Culver City. We do special education, regional center, and disability discrimination. The disclaimer is that we want you to know about your rights, and we try to answer your questions to the best of our ability in a general way. But any specific problem that you have would benefit from a consultation from an attorney. If you're in Southern California, you can reach out to Hirji and Chow for complimentary consultation. If you are in Northern California or the other 49 states, I'd recommend you go to COPA.net and look at the lawyers directory in there. A lot of those people are good people who have, been in the trenches because they've had their own personal experience with disability, and you can call those people and get help. But make sure if you've got a specific problem, you get somebody to pay some pretty focused, specific attention to it in a timely fashion.
Great disclaimer. So, Bonnie, we've got a couple of short questions for you this week because we wanted to leave some time because you started out talking about LRE last week, and LRE is very important to all of us, and it is IEP time. And honestly, that's one of the biggest things that gets discussed is, where is the best placement for somebody? What's the least restrictive environment? But, okay. So partially, both of these questions have a little bit to do with that. So the first question is, I know Bonnie said that there's a place where we can make notes on the IEP if we disagree. Where is that? I don't see it. So where do we find that, Bonnie?
That's a really good question. And the answer to that is you're going to create it. Because where it says there's 2 places that parents potentially could sign the IEP. There's a consent portion and there's a participation portion. Participation portion has no legal significance beyond the fact that you showed up there and you participated, and you had an opportunity to give input. It doesn't mean you agree with what the IEP team said, and it doesn't even mean that you agree that the IEP team has documented what they said correctly. So then there's the consent portion of the IEP, which sometimes says I consent, sometimes it says I don't consent, sometimes I consent but accept, so, except for the following concerns. So what I suggest that parents do is they think about the bases that they're going to agree with or object to when they sign the IEP and create a whole separate document. So all you need to do is where it says I consent, you go in there with your blue or black pen, you make 3 asterisks, and then you write, please see attached letter dated blah, 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 re-IEP of blah, blah, blah date. I've been known to just say, please see attached letter. And then you send them the attached letter, and the attached letter is an IEP response, and it should contain a response to the different parts of the IEP. So one of the parts of the IEP is going to be eligibility.
You just became a mystery guest.
Yeah, what happened? Why am I all dark all of a sudden? That's strange.
Yeah, I think just the camera tilted and all of a sudden you were that mystery guest. I wanted
strange. Yeah.
Okay, now we can see you again.
Okay. Anyway, so the first bit of business as far as the consent is, do you agree to the eligibility? If you do, you just say, I agree to eligibility. If you don't, you say what? Then you talk about whether or not you agree with the goals. And if you do, fine. If you don't, you can go through one by one and talk about why you think that they're not measurable. Then you get to the accommodations, and you can comment on the appropriateness of those. You do, you don't accept. And then you get to placement. You make your placement comments. And as far as responding to an IEP, In California, you have a few options. You can either provide a full consent or no consent, or you can provide partial consent. And partial consent would be saying, I don't think that this IEP offers my child a free, appropriate public education, but you have my permission to implement the IEP. That's obviously all too much information for what they give you on the IEP document, which is essentially one line. So that's why you can see the utility in writing, asterisk, 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 the attached letter. And you could even have a discussion about something else in the letter, like that the district's characterization of what was said is wrong, or you could have a discussion about why you're requesting independent educational evaluations, or you could document any other concerns that you think are important for the IEP team to consider. So take as many sheets as you want and be as detailed as you want, and make sure that you include at the end of your letter that you request that this document be attached to the IEP. And that's how you do it.
Okay, that's fabulous.
Ready,
that's
Shannon?
like the master class.
Okay.
Okay, so the next question that we had, I want my son to not be in special ed. He's smart. How can I get him in a general classroom with a one-on-one aid?
Okay, so I misunderstood this question, which tells you I was going too fast this week. This question I thought was unclear. It's perfectly clear, and it fits nicely into what we're going to discuss today. She's not saying she doesn't want special education eligibility, which is what I thought. She's saying her son is in a special day class, and he or she is smart and is not getting anything out of those classes, and she wants him in general ed. How does she do it? So let's start with something that a very wise person told me a long time ago, a parent of children with autism who also is a special education attorney. At the time, probably 10 or 15 years ago, I had a student in a school district in Orange County who was in middle school and transitioning to high school. And the parents had gone and visited the class and were horrified to see that there was nothing going on there. There was no learning. It was a giant babysitting class. They were watching movies. There was not really any work being done. And I sort of called my friend in despair and I said, what do you do when the special education classes are so bad? And she said, Bonnie, what you have to do and what you have to advise your clients is that they keep their kids in general education for as long as they possibly can, because there really aren't very many good special day classes. Now, I know that when we say stuff like this on the air, it freaks people out. And sometimes I wonder if I'm coming on too strong and being direct with people and telling you that a lot of what I see in special ed is really dysfunctional. But, I'm not getting any younger, and this has been my experience, and I'm sort of at the point in my life where I think it's important to talk about what is. So I will tell you, there are probably exceptions, but most special education classes are segregated, expectations are low, and there's not a lot of learning going on there. And that's contrary to law because there's a very strong preference in the law for the child to be educated in the least restrictive environment with supplementary aids and services that allow that to happen. So that sort of flows into what we started talking about last week, which is what is all this talk about least restrictive environment and how does it apply to our child and what does it mean? And we didn't have very much time last week, so we just got through some definitions, and now we're going to dive in here and probably spend a couple weeks talking about least restrictive environment. So, are you ready, Shannon?
I'm ready.
All right. So, first of all, I just took the camera again the wrong way. What happened? Okay. First of all, there's provisions in both federal and state law that concern your right to the least restrictive environment. And I would say almost bar none, least restrictive environment is the most important part of the IDEA. And it doesn't always mean general ed, although I've started the program today by saying those of us that can should be striving really hard to have our children be in general ed with supports for as long as we can. And if we're going to have them in special day classes, it's very important to get outside input about what's going on in that class, because I don't think the district will tell you. And that may mean that you visit, but it also probably means that you have somebody else that has more familiarity with how to evaluate a classroom placement visit. In my practice, it's oftentimes it's the neuropsychologist or the speech therapist or something, but it also can be the BCBA supervisor from your home ABA program, and that can oftentimes be an easy way to get somebody in and have them see the classroom, because the parent is saying, well, I want to make sure there's consistency between my home and school program. How can my home ABA program work on these things if they don't know what's going on in the school environment? So consider doing that to get a handle on what your child's setting is actually providing. As far as the right to least restrictive environment, I'm going to give you a bunch of information, and some of it I have to read because I'm quoting from federal and state law. So, federal law provides that each local school district must ensure, to the maximum extent appropriate, so we've got a maximization standard, children with disabilities, including children in public or private institutions or other care facilities, are educated with children who are not disabled, and special classes, separate schooling, or other removal of children with disabilities from the regular educational environment occurs only when the nature or severity of the disability of a child is such that education in regular classes with the use of supplementary aids and services cannot be achieved satisfactorily. So obviously what we're going to be talking about is supplementary aids and services, and there's going to be, in the majority of cases, if the right supplementary aids and services are employed, the child's going to be able to be, the child's going to be able to be successful in the regular education environment. And sometimes when I do the research for these autism-live calls, I think, wow, like this language is really powerful. And we should be going into our IEP meetings and reading this stuff to these people and making them justify, in response to the language, what it is that they're actually doing. Because they're supposed to be, using all of their smarts to figure out how to do as much inclusion as possible. And they are given a lot of options in terms of how to do this, and yet I don't see this actually happening practically speaking. So it's interesting because, for example, in order to ensure that the LRE mandate is followed, the IEP is supposed to include a statement describing how the disability affects involvement and progress in the general ed curriculum, okay? There's got to be a statement of annual goals to enable students to be involved, and there's got to be markers for evaluating progress in the general curriculum. So, loosely speaking, these days people are using a form IEP, and they probably, they're using a template IEP, and it probably has reference to those things. But then you got to ask yourself, do they gloss over it, or is there any meaningful discussion about it at your IEP? You should be having that discussion. So for the person that has the very smart child who's in a special ed class, what needs to be looked at is what, for example, what kind of supports does he need to be in a less restrictive setting, and what kind of curriculum modification does he need to be in a less restrictive setting? And the law, federal and state law, is very clear that even if you can't do the general ed curriculum unmodified, if you can otherwise participate in there with a modified curriculum, the law is giving you a preference, and you're entitled to try that. But I don't think that most people know that that's an option. So I can go on if you don't have any questions, Shannon. But
no, I'm loving it. Keep going.
Okay, so the IEP must spell out services and modifications, supports for school personnel to be provided to the student so that he or she can participate in general ed, even if he needs a modified curriculum. And he also should be allowed to participate in extracurricular and non-academic subjects. Students shall be offered special assistance programs that promote maximum interaction. Oh, I just went dark again. Sorry. Maximum interaction with non-disabled peers in a manner that's appropriate to the needs of both. So that's what we're supposed to be seeing, but I don't think you're seeing it a lot. That's right in our Ed Code. That's California Education Code 5656001 for NG. And if you want to read some of this stuff, all you have to do is Google it. If you put in California Education Code 56001, you'll be able to read this for yourself. And I think that knowledge is power. I think that when you start reading what's in the law and you start appreciating this preference for inclusion, essentially, you're going to be a lot more comfortable trying to push the district to do more of this stuff to make inclusion happen, because they're supposed to do a lot.
It's pretty powerful, Bonnie, I gotta say.
Well, that's what I felt like when I was reading this. It's kind of like we're all not really appreciating how powerful the language is in support of our goal to keep our kids in settings that are as normal as possible. The law says that special education classes should be utilized only when the circumstances are such that in a regular education class with aids and services, the child can't be educated satisfactorily. Well, we know that a lot of the time that's not the way it goes, right?
Most of the time it's the reverse, and the school acts like it's the reverse. And usually if you say to a school something like, well, can't we just try it? That's like heresy. They don't want to just try it because it costs them a lot of money.
That's why it's so important that you go in there armed, understanding that your child has a right to be fully included to the maximum extent practical. Okay? And there are cases that look at exactly how that balancing is effectuated. And the most important one for California, it's not a particularly new case, it's from 1992. It's called Holland versus Sacramento Unified School District, and I'm going to quote from it. But Holland looked at the question of whether somebody could be excluded from general ed, and if so, what the analysis had to be before you exclude them. And Holland is still the law, and it's a strong decision for parents. So again, you might want to Google Rachel Holland versus Sacramento Unified School District. You ladies and gentlemen are smart people. That's why you are able to advocate for your children at the level that you do. Imagine how great it's going to be when you can actually understand what the analysis is as far as least restrictive environment, and you can pose these questions to the district.
Absolutely.
Because the questions we're not posing are sometimes the important ones. The question of research-based intervention, which is not inclusion, but it's to me, it's like the equally important question. The law says whoever recommends an intervention for a student needs to do so based on research to the maximum extent practicable. And if there's research out there that's readily available for teachers, and I believe there is research, then why isn't it practicable? And the person on the IEP team that's recommending a placement or a particular type of intervention ought to be able to say to the parent, you know, I'm a highly qualified teacher, and I'm here to talk to you about the research and explain the research and why I'm picking this way to go with your child. It's not like they get a free pass and they don't have to explain it to you. So that's something to bear in mind. And similarly, if somebody has your child in a special ed class and you don't believe he belongs there, you need to start having the IEP team have a meaningful discussion about the least restrictive environment analysis. And that doesn't just mean checking the box on the IEP document that said, we discussed the continuum of placements. It means a real discussion about what it's going to take to include your student to the maximum extent that it can be done.
Absolutely.
So
we got about 2 minutes, Bonnie. What, do you want to?
I got lots more stuff. I mean, to me, when I started reading about LRE, I felt like somebody had like taken my head and turned it, around so that it was like attached in the opposite direction.
Yeah.
Because we're always sort of gracefully or graciously accepting, crumbs that were given. Oh, thank you, thank you. We should be demanding LRE. It's our right under the law. It's a strong right. So,
Amen.
So that's the difference, I guess, between theory and practice. But if we want to move the law forward and enforce the law that we have, we need to start talking at IEP meetings about, what LRE looks like for the student. So in the time that I have, I want to tell you about a couple of California Education Code sections you might want to look at. One is 56.346.2. That talks about your child's right to participate in general education to the maximum extent possible. So read that, see what it sounds like to you. Take a look at 56.303. It says you can only refer somebody to a special education class after first considering all of the general ed resources that are available would allow him or her to participate in general education. So next week, we can start talking about the specifics in terms of how you do the analysis and what factors are considered and things like that. If we're out of time, I can stop. If we're not, I can read a little bit more from the federal.
Unfortunately, because I did not manage time, we are out of time. But we can pick it up here next week if that's all right.
Sounds good. Yep.
All right. So tell us again, how do we reach here, Gian Chow?
310-391-0330, lawyer4children.com. Good questions, good discussion. We'd love to hear from you. Keep your heads attached to your bodies. Everybody's having a hard time in the spring because school's about to end and things aren't fixed yet. We'll get through this.
Absolutely. And I love that we'll get through it with you, Bonnie. Thank you so much for being here and for sharing your time and wisdom. We so appreciate it.
All right, everybody. See you next week in Killer Ed Land.
All right. Bye-bye. Hey, thanks for watching Autism Live. To subscribe, click here. And if you'd like to check out some more of our videos, click here.